Joan Esposito. Live, local, and progressive. Filling in today for Joan, political science professor at North Central College, author and podcaster, William Monk.
Welcome back to WCPT. We are now joined by Professor David Super, who is a constitutional law scholar at Georgetown Law School. His official title is the Carmack Waterhouse Professor of Law and Economics. In addition to Georgetown, he's also taught at Columbia, Harvard, Howard, Maryland, Penn, Washington Lee, and Yale. He is here today to help us make sense of the legal questions that have arisen from the flurry of activities we've seen this first 6 weeks of the Trump administration. I've really been looking forward to this conversation. Thank you so much for joining us, David.
Thanks for having me.
So before we get too far, it's probably important to note that Georgetown Law School found itself in the news this week, and specifically a target of the Trump administration after Trump's top federal prosecutor in Washington, D.C. sent a letter that his office would not hire any of the students' graduates if it didn't eliminate the diversity, equity, inclusion elements of its program. I'm curious to give you a little bit of space and react to how Georgetown, how you are feeling about all of this.
Well, it's absolutely outrageous that they're trying to leverage government power to tell a private university how to teach and what to teach. Georgetown's a Jesuit institution. We follow the principles of the Jesuits, which require looking at everyone as a full human being and taking them as such. It's disappointing that they're so unwilling to accept that.
I went to Marquette University for a master's, and you're right, the Jesuits, they get kind of lathered up when somebody from the outside kind of tells them how to do its work. So I really appreciated it. I thought your dean had a really compelling letter in response and sort of pushing back a bit. So, let's think about this little big picture. So for the average American, trying to make sense of what we're watching, especially on the legal front, it can be overwhelming. You know, one of the things I've most appreciated about your writing is your ability to simplify what we're watching play out. So we're going to dive into the weeds in a little bit, but can you offer a big picture assessment of what you believe Trump is attempting to do to the constitutional order and the overall legality of some of these efforts?
Well, various presidents in the past have made particular attempts to change particular constitutional rules. But President Trump, more than any of his predecessors, is trying to change everything all at once and change us from a checks and balances system to a strong presidential system where the courts and Congress are bit players.
Okay, so to sort of making that huge transition, would you say, there's lots of conversation about whether we're in a constitutional crisis and, how grave or dangerous this moment is. There's no universally accepted definition for when we've entered a constitutional crisis. But in your assessment, do you believe we are entering a moment of constitutional danger?
Oh, we absolutely are. Our system was built on checks and balances. Those were the political theorists that the framers related to and tried to emulate. That's been the essence of constitutional law from the very beginning of our Constitution. And President Trump rejects that. He believes we need a strong president who can do whatever he wants and is largely unchecked by Congress and the courts. Trying to change a country's constitution is a constitutional crisis.
And do you, as you think about through history, are there other moments in history that you might compare this to say, like, hey, this is as significant as this? I mean, a lot of people obviously talk about the Civil War and then the challenges there. Are there other moments that compare to this, or is this unique?
This really is unique. Obviously, the Civil War was an effort to end the country by splitting it at least in two, and that's dramatic and important in its own way, but there's really no other precedent to this. You might have seen one of the Great Depression, but Franklin Roosevelt chose not to do it. Had he gone ahead with his plan to pack the Supreme Court, we might have started to get to the place that Mr. Trump is trying to take us now, but Roosevelt backed off. His allies in Congress said that was a bridge too far, that checks and balances were important, and as frustrated as he was, President Roosevelt stood down. There's no sign that President Trump's planning to stand down.
That's really significant. So maybe we can talk a little bit about some of the phrases and the legal terms we're hearing thrown around. And a phrase that we're hearing a lot today, especially in the legal cases against Donald Trump and his administration's actions, is arbitrary and capricious. And I had to look this up, and it comes from the Administrative Procedures Act of 1946, something I have not read, but I'm guessing you have. The basic idea being that the government cannot do things in a way that is arbitrary and capricious. Can you explain what that means and how we should think about this concept as it applies to the Trump administration and some of what they're doing?
Yes, arbitrary and capricious means ignoring the facts or ignoring reasonable arguments that are made. You don't have to agree with me, but you have to listen to me. And the courts have generally been very reluctant to find things arbitrary and capricious when it's a difference of opinion. But what we're seeing here is not a difference of opinion. For example, they sent out letters terminating lots of ongoing research projects for the National Institutes of Health. And the letter said, well, some projects like yours are problems, or many projects like yours are problems. But they made no effort to examine whether the particular project they were terminating was a problem. That's arbitrary and capricious. They could have looked it up before they just decided based on generalities that they didn't want to fund these people and wanted to stop their work in its tracks.
Have they put out a legal response to this? I mean, do they just argue we're not going to worry about something being arbitrary and capricious? Because it feels like with a lot of things, Donald Trump, they sort of lean into the illegality or the ways in which they're challenging the Constitution.
Well, that is a striking thing about it, is that many of the things they're doing, they could do 80, 85, 90% of the same thing legally, and they're making no effort to try. They're deliberately defying one law after another and daring the courts to stop them, which so far has been a mixed record. But their general view has not been so much to put forward their constitutional law theories as to try to be evasive. So the courts enjoin an action and they read into the court's order, oh, you're only enjoining us from doing it on the basis of that memo. Well, we'll pull out a new memo. And the court order doesn't say don't do it on the basis of that memo. Some of them say on the basis of that memo or anything similar, and yet they just go ahead and do the same thing with some new justification that is all but indistinguishable from the old one.
This sort of connects to this next term I wanted you to talk a little about, which is the idea of impoundment. And it's another term that the public is suddenly hearing a lot about. Can you explain how that relates? This is the presidential practice of impoundment and what we need to know in terms of understanding Trump's actions.
Yes, impoundment is taking money that Congress has appropriated and told the president to spend and refusing to spend it. President Nixon, towards the end of his term in office, made a lot of impoundments, found lots and lots of domestic spending that he didn't like, much of which he'd himself proposed, but he changed his mind on it and decided he didn't want to spend it. And that was challenged by the people who were entitled to the money under the Appropriations Acts. And he lost every single case that was decided on the merits. It went up to the Supreme Court. He lost 9-0 there. Justice Rehnquist, very, very conservative justice, joined the rest of the justices in finding that what he did was unlawful. So this has been forgotten about largely in all the years since President Nixon, more than half a century, and now President Trump is bringing this back and is announcing he's going to refuse to spend money that Congress has appropriated for a wide range of purposes, and has continued to refuse to spend money even after he's lost in court.
We need to, this is really, really interesting. We need to take a quick break here, and we're going to come back with David Super and talk more about, when we come back, we're going to talk about what he argues is a presidential superpower that seems to be developing. We'll be right back on WCPT.
This is Chicago's Progressive Talk, 820 AM, WCPT Willow Springs, and online at WCPT820.com, where facts matter.
Joan Esposito. Live, local, and progressive. Filling in today for Joan, political science professor at North Central College, author and podcaster, William Muck.
Welcome back to the Joan Esposito Show. We are talking with David Super, who's a law professor at Georgetown Law. And I wanted to pick your brain a little bit about, you've talked about a presidential superpower. And earlier you mentioned that some of the actions taken by Trump, which you highlight as illegal, could have been done within the law, given the Republican majority in Congress. Trump could have worked within the requirements of the Impoundment and Control Act or a lot of other litigation or legislation. Yet the administration chose not to follow that process. And they intentionally seem to be violating some of the laws and Supreme Court rulings that regulate the conduct of the president. You write about that choice and suggest it's evidence of a broader desire to establish a presidential superpower. Can you tell us a little bit about what you mean by that?
Yes, the Constitution says that the president shall take care that the laws be faithfully executed. That's always been interpreted as meaning that Congress writes the laws subject to a presidential veto, and the president then carries them out. Lots of discretion on how they're carried out, but the basic laws are set by Congress. What President Trump seems to be saying is that Congress cannot regulate anything about the president, and therefore when the Congress says that you must give the public notice and the opportunity to comment before you change important regulations about public employment, if the president doesn't like that, this administration says he shouldn't have to follow it. When Congress says you should spend money on this and that, if the president doesn't like it, his view is that he shouldn't have to do that. This suggests that Congress perhaps could offer some general suggestions, that Congress could regulate conduct between private parties, but anything to do with what the administration does would be subject to the final control of the president.
Now, would this be what we often hear of as the unitary executive theory? Is that sort of the broader idea that's playing out?
No, this is not that. The unitary executive theory says that the president can overrule cabinet members or other officials in the executive branch, and there are some disputes about the margins of that, but that's a position that has a long history in this country. This is more converting us to the French system, where you have a president who is largely unchecked in large areas of policy, and the legislature is expected to be subordinate.
That's interesting, although it gives me something else to worry about, because I was just worried about the unitary executive theory. Now I got to think about both. So, when you're writing about this, that you note that the administration's current focus is exercising this asserted superpower on fiscal, regulatory, and personal matters. But one could imagine it trying to extend the superpower's reach into the civil rights and civil liberties realm. And I have to admit, when I read that, it hit me with a thud. Can you explain to us what you mean by that, extending this to thinking about civil rights and civil liberties?
Yes. The president has already said that he's going to take severe action against anyone engaging in what he calls diversity, equity, and inclusion activities, which he hasn't defined, and there's no generally accepted definition of them. Some activities, such as making classrooms accessible with wheelchair ramps or putting Braille cards on elevators so that people with visual impairments can go up and down, are not just good ideas, but they're required by federal law. This appears to mean that he would be able to say that those activities are no longer allowed.
The ramifications of that are really quite significant, right? I mean, that's a dramatic expansion of power.
It is, and we've generally been skeptical in this country that anyone has a monopoly on wisdom. Our Supreme Court has 9 justices because we don't trust any one of them or even any 3 of them. And our president is the first among equals, subject to control by Congress and the judiciary, because we don't like single authoritarian figures. We fought a revolution against George III, and we rejected the idea of setting up an American monarchy to replace him.
A second principle you've highlighted in terms of your concerns about the Trump administration is their attempt to eliminate what you describe as neutral arbiters of fact. Who are these neutral arbiters, and why is the Trump administration attempting to eliminate them?
Well, there are a lot of them around. Obviously, judges are expected to be neutral in ruling on cases that come before them. Journalists, for the most part, are accepted to be neutral. We've got some that are partisan Democrat or partisan Republican or whatever, but the tradition of journalism has been being honest about the facts. Universities are expected to adhere to the research, and you see academics writing articles where they say, I don't like these results, but this is what the research tells me. Scientists do that, and perhaps most importantly for these purposes, government civil servants who are protected against partisan interference and were thought to have secure jobs provide that kind of security so that you can trust what they say. The courts rely on them in all sorts of ways. When an FBI agent testifies in court, that's seen as a big deal. Well, now we're seeing FBI agents fired because they conducted lawful investigations of people who are now friendly with this administration or indeed leading this administration. That means that you can lie, and there's no one who's going to be widely trusted to call you out on that. People lie usually for bad reasons, and we should be concerned about that.
It's sort of a bedrock of good democratic governance is to have these neutral arbiters that elevate and hold people accountable. You know, as we talk about this, I can't help but wonder how you assess the decision of the administration to fire the senior military lawyers in the Army, Navy, and Air Force, as well as the decision of the administration to revoke the security clearances of all the lawyers at Covington and Burling, the firm that was representing the special counsel Jack Smith. I mean, it seems like a pattern of eliminating neutral arbiters and then targeting those who may slow down the process.
Indeed, it's quite alarming. Even more alarming than firing the senior military lawyers was the stated reason for doing so, that they might object to things that the administration wants to do. Well, that's exactly why we have judge advocate generals in the military, because the military has enormous power, and we want some independent assurance that that will be handled lawfully and in accordance with our Constitution. So I found that quite chilling. We've seen other countries have terrible abuses when the military went on a rampage, often at the behest of the sitting government. We've always thought we were secure from that here, but when you start purging the people who are responsible for making sure we don't get overrun by our military, it has to be worrying.
Yeah. I'd like to talk to you a little about you highlight in your writing a legal strategy that the Trump administration is deploying as it relates to all of these temporary restraining orders, or TROs, that courts are placing on the administration. So the courts have been active and in a number of instances have told the Trump administration to stop or to slow down. But you write that while the administration assures the public it will fully comply with the court decisions, the on-the-ground reality suggests something very different.
Yes, they've been ordered to stop across-the-board freezes of appropriated funds from Congress, and they've simply not done it. And many of the funds go to small nonprofits, quite a few of which are now bankrupt. They've laid off all their employees, closed their doors. If it is ultimately found that what the administration did is indeed illegal, it'll be irreversible. That's precisely the reason why these injunctions were granted, but by refusing to follow them, the administration basically wins the case, whatever the courts may say.
Is there a response to that, right? I mean, if the administration says, well, we can't because of these, does that sort of end the legal process, or are there other remedies to pursue at that point?
The courts can act faster, recognizing that these are often very vulnerable, small religious or secular nonprofits that are being wiped out. The courts have been giving the administration a great deal of deference, assuming it will comply with court orders, which it federal administrations typically have done, and have not treated them as untrustworthy, have given them lots and lots of time. I was reading an order today where a court found that the administration had violated one of its orders by continuing a funding cutoff, and it ordered the administration to file a statement next week telling the court what it was doing. If you or I violated a court order, we'd be writing our statement from jail. But the administration is being given extra time, and in the past, that would have made sense, but this administration has made clear it isn't interested in complying with court orders it doesn't agree with, and much of what it's doing is going to be irreparable by the time the courts catch up.
It strikes me as I think about USAID, that may be part of what we're seeing right now, where, I mean, the courts have sort of intervened to say you can't move, you got to slow this down. But if you dismantle the infrastructure, if you dismantle the institution, if the people are gone, even if the courts were to say, okay, start that funding again, the institution, the organization wouldn't be in place to even do that. It's a powerful strategy.
Well, indeed, that actually did happen. A court on February 13th did order them to resume funding. They didn't. On February 20th, it told them again to resume funding. They didn't. A few days later, it reiterated that. They didn't comply. Finally, the court ordered them to start the payments right away, and gave them a deadline of a couple days to do that. The administration went to the Supreme Court, said that this was unreasonable and intolerable, and the Supreme Court this past week ruled 5-4 that the lower court's order could stand, and that the administration did need to comply with this early order, and we'll now see whether, with even the Supreme Court weighing in, they will actually restart these programs. But we're told that many of the organizations that they funded in very poor parts of the world have already gone bankrupt. So they may get some funding out. It may be in time to save some of their grantees, but others will be gone. And as you say, they're going to have a hard time doing much of this because they've gotten rid of so much of their workforce.
That's absolutely right. So, well, I'll maybe wrap up with a big picture question on the Supreme Court. And I'm curious to get your thoughts on what role you believe the Supreme Court is going to play in all of this. It's undoubtedly that it's going to be the final arbiter of whether Trump's actions are legal or constitutional. In your writings, you express some worries over whether the justices will be up to the challenge. What are you thinking about as these cases inevitably make their way to the Supreme Court?
The administration is doing a great many things that are troubling, some of which are legal and some of which are not. The cases involving objectionable but legal things, the court's going to back the administration. There's no real question about that. But on the things like these funding cutoffs, like these arbitrary and capricious rescissions of grants, like rescinding grants when there's no legal authority to do so, the mass firings, those things that clearly contravene law, I think are going to be very troubling to this court. This court is populated by self-described textualists who believe in following the word of the law and not policy opinions. This will be a good test for them.
Much to come. Well, thank you so much. We've been joined by Professor David Super, who's a constitutional law scholar at Georgetown Law School. Thank you, David. This has been really, really insightful. I feel like our listeners have learned a lot about the law today.
My pleasure.